when joint legal custody parents disagree about an IEP in Utah. Some of the strongest child custody disputes are no longer fought only through parent time schedules, exchange disputes, or direct allegations of abuse. Increasingly, they are fought through institutions, schools, therapists, counselors, diagnoses, treatment plans, behavioral interventions, and sometimes individualized education programs, or IEPs. An IEP can be an important tool for a child who genuinely needs support. It can provide accommodations, specialized instruction, behavioral assistance, speech services, or other interventions that materially improve a child's education. But in some high-conflict child custody disputes, the IEP process can become another front in the war between parents. That does not mean special education is illegitimate. Many children genuinely need services. Many parents fight hard for those services because schools can be slow to identify and support struggling students. The problem is that the educational system is built on concern, advocacy, documentation, and professional deference. Those features help vulnerable children. They can also be exploited by manipulative adults. Sometimes a parent's goal is not merely to help the child. Sometimes the goal is to become the child's psychological safe parent, while slowly portraying the other parent as detached, insensitive, uninformed, emotionally unsafe, or unable to understand the child's needs. One parent becomes the dominant communicator with teachers, counselors, therapists, and administrators. That parent attends every meeting, sends frequent emails, monitors every concern, and presents himself or herself as deeply attuned to the child. Meanwhile, the other parent may begin to look peripheral, sometimes fairly and sometimes unfairly. The hardest reality is that legitimate concern and manipulation can coexist. A child may truly struggle academically, socially, behaviorally, or emotionally. At the same time, one parent may exaggerate, amplify, or weaponize those struggles. Conversely, some parents minimize real problems because they do not want the child labeled, medicated, accommodated, or viewed as disabled. There is no simple shortcut. Schools also struggle with these dynamics because schools are educational institutions, not family court investigators. They are trained to respond to concern and collaborate with engaged parents. They are not usually trained to detect subtle alienation, coercive family dynamics, personality pathology, or litigation-driven narratives. Joint legal custody does not neatly solve the problem. It usually gives both parents the right to participate in major educational decisions, but school districts operate under federal special education law and internal policies, while family courts often move too slow to referee these disputes in real time. The danger is not the IEP paperwork itself. The danger is the gradual construction of a child identity built around dysfunction, fragility, anxiety, pathology, and dependence. Children need support when support is truly needed, when they also need resilience, competence, confidence, accountability, independence, and room to grow. Courts should not simply defer to whichever parent appears most alarmed, most therapeutically fluent, or most institutionally aligned. The better question is which parent is helping the child become more functional, more resilient, and more independent.